and welcome to autumn's edition of the HR Breakfast Club. Great to see everyone back again, some familiar faces. For those who don't know me, my name is Mark Keating. I'm a partner in the employment team at Kuits. So just some housekeeping points to start with, the boring bits before we get into it. If you do have, obviously, your mobile, you can just put it on silent. Just check so there's no kind of disruptions. Questions, if you can leave any questions to the end, just because we've got a lot of content to get through. The team will also be around afterwards if we need some kind of confidential space. And third, it is Thursday, so we don't normally have a fire drill. So if the alarm does go off, and it has happened at one of these sessions, then just go down the 7 flights of stairs, out of the building, and congregate just across the road at the liquor store. Okay, so a lot's happened, I guess, since our last HR Breakfast Club. A lot has been in the news about sexual harassment, particularly at the BBC. Romances at work as well has been on the agenda for any HR people that have gone to a Coldplay concert recently would have experienced that. By the way, if there's anyone here with somebody that they shouldn't be with, don't worry, it's a safe space, you'll be fine. So we're going to be talking about a few things today. Guests are our own speakers. We've got, so really proud today because we've got 2 trainees that are going to qualify into our team as newly qualified solicitors. We've got Tyler Ross at the back. Some of you may have met at previous HR Breakfast Clubs. And we're joined by James Kearns, who is going to deliver the case law update. And then James is going to talk about Lidl as well, been in the news. If anyone's come across that in the last week. And then we're joined by Lauren Ogden, associate in the team, and Kevin McKenna, head of the team, to provide an update on the Employment Rights Bill, which apparently is going to change our lives. So, without further ado, James.
Morning, everyone. So as Mark said, I'm going to start with a case law update. Firstly, looking at a case regarding redundancy, and then I'm going to look at the recent agreement that Lidl have entered into with the Equality and Human Rights Commission. But I think both cases kind of highlight important points which you can take from today. So we'll start with the first case, which is Hendy Group Limited versus Kennedy. And so the facts of this case were that Mr. Kennedy was employed by Hendy Group since 2013. Hendy Group operated as a car dealership, and at the point of his dismissal, he was a training manager. Mr. Kennedy he had 30 years of experience in the motor trade, specifically in sales, before taking on this role. And in 2020, much like for many companies, a redundancy situation arose due to the COVID pandemic. And Mr. Kennedy accepted there was a genuine redundancy situation and that he was fairly selected for redundancy within his team. However, he claimed that his dismissal was unfair because the company had not adequately or fairly considered the possibility of him continuing to work for them in an alternative role. And then at a consultation meeting in 2020, Mr. Kennedy was told that he could apply for posts listed on the website, on the internet actually, but the HR department took no steps to assist him in finding alternative employment, and his line manager's only support was to offer to speak to someone on the phone. And so shortly after being given notice, Mr. Kennedy was required to return his laptop and had no access to his internal email or to the internet. So essentially he had the same access as a member of the public to these vacancies. And then during the period between Mr. Kennedy being given notice and his dismissal, several sales jobs became available across the company. Mr. Kennedy applied for them, he interviewed for one of them but was unsuccessful. And the hiring managers for those roles were also not informed that he was at risk of redundancy. And so in terms of the tribunal's initial decision on this, they found that Hendy Group had failed in their obligations to Mr. Kennedy to seek to avoid dismissal, and they held that he had been unfairly dismissed and ordered to pay the company compensation of just over £19,500, with no Polkey reduction applied. And just to pause on the facts of that, for those that aren't aware, a Polkey reduction or deduction comes from an old case of Polkey and AE Dayton Services Limited, and essentially means that if a dismissal is found to be procedurally unfair, the tribunal will ask, would the employee have lost their job anyway, even if they had followed a fair procedure, a fair process? And if the answer is most likely yes, then they can reduce the compensation, and that's usually expressed as a percentage. And so the company Hendy Group, they appealed to the Employment Appeal Tribunal on the basis that the tribunal had applied the incorrect test when considering whether the company had properly considered alternative employment, and that the tribunal had failed to consider whether a Polkey reduction should be made. But the EAT dismissed all grounds of appeal and upheld the tribunal's decision. And the judge's conclusion was that the company did nothing in terms of alternative employment. There was also no other evidence of steps that a reasonable employer might have taken, such as speaking to employees about where their interests lie or assisting in identifying conversations about other roles. And effectively, the duty was whether an employee could be offered alternative employment in consideration of the size and administrative resources of the employer. And in this case, Hendy Group was a large organisation and had relatively large administrative resources. And there were a large number of vacancies in a short period of time for which Mr. Kennedy, on paper at least, was suitable to be considered for. And also no Polkey reduction was applied. And so in terms of the key takeaway points that you can take from this case, I think in terms of redundancy, a fair redundancy process includes a proactive effort to identify and support redeployment opportunities. It's a positive obligation on the employer, and mere signposting to listings is not enough. I think the case also shows that even where redundancy selection is procedurally sound, an employer can still fall foul of legislation if it fails to engage meaningfully with alternatives to dismissal. And I suppose the case is kind of unique in the sense that the employer cut off systems access and failed to inform hiring managers that he was at risk of redundancy, and essentially that undermined the fairness and will be scrutinised as it was in this case. So moving on to the next case. So as the slide says, so Lidl have recently entered into a legally binding agreement with the Equality and Human Rights Commission. And this actually comes off the back of a case called Hunter and Lidl GB, Lidl Great Britain Limited. So I'll just briefly go into some of the facts of that case. The claimant, Miss Hunter, was employed by Lidl as a customer assistant from February 2019, and then she was promoted to shift manager in August 2020. And almost immediately within that role, she was subjected to unwanted advances and comments by a fellow employee. She complained to the store manager, who told her to, quote, take it as a compliment. And he also said that he wasn't surprised by what had happened and made a joke about it. She continued to be harassed, and including a deputy store manager, and he made a number of highly sexualized comments about her and to her. And despite raising concerns verbally and requesting a transfer to a Lidl store with a female manager, Lidl failed to take any appropriate action, and she eventually resigned in 2021 and brought a number of claims, including for sexual harassment. And so the tribunal's decision in that case was that they accepted her claims, and that the behaviour she'd endured reflected the culture of that store, and she was awarded a large award of just under £50,900, and that included a £22,000 award for her injury to her feelings, plus interest on that award, of that part of her award, of over £7,600. So that reflects kind of an award that's kind of the higher end of the middle Vento band applied at that time, which kind of reflects that she was experiencing sexual harassment over a prolonged period of time. And Lidl ultimately failed to take all reasonable steps to prevent that. And part of that was that they failed to train managers on their anti-harassment policy or explain their duty to create an environment where harassment was not tolerated or deal with complaints in line with its procedure. And also, as it says, no risk assessments had been conducted. So just on kind of the position under legislation, as you'll know, under the Equality Act, employers are vicariously liable for acts of harassment committed by their employees unless they can demonstrate that they've taken all reasonable steps to prevent the harassment from occurring. And for those of you that have been to our prior HR breakfast clubs or are aware of this, in October 2024, there's a new proactive duty, preventative duty, which requires employers to take reasonable steps to prevent sexual harassment specifically. But I think as Kevin and Lauren will come on to, under the Employment Rights Bill, that obligations will be stronger and will become an obligation to take all reasonable steps to prevent sexual harassment. So in terms of the actual agreement itself that Lidl have committed to, it's a binding agreement known as a Section 23 agreement. And I've just put on the slide some of the commitments that they've committed to. And ultimately, it's important to note that the EHRC, the Equality and Human Rights Commission, are the regulatory body that are responsible for enforcing the Equality Act, and they have a range of powers available, which includes Section 23 agreement. And so following that agreement, Lidl's taken a number of steps, which included additional training, further bullying and harassment training specifically, and that was a broader rollout across the business. So I think there's quite a lot that can be taken from this. I think obviously the headlines are focused on a major major retailer, but I think the implications are far-reaching for all businesses. Obviously, all employers of all sizes, excuse me, for protecting staff from harassment. And while the Lidl case shows that regulators are willing to step in where there's evidence that employers haven't done enough, it also shows that they have power to investigate, but also impose binding agreements, and smaller businesses aren't immune from that scrutiny. So I think there's kind of four main points that you can take away today from this case. I think firstly, in terms of policies, it's not enough just to have a policy in a handbook. Employers need to demonstrate that staff are aware of it, that it's regularly reviewed and it's followed in practice. And in terms of training, managers and staff should receive regular practical training on what harassment looks like, how to challenge it in the business, and how to raise concerns. And I think the Hunter case does also show an important point in terms of reporting procedures, that employees need a safe, confidential way to report harassment, and confidence that their concerns will actually be acted on. And I think finally, just that the culture starts at the top of the business. If managers dismiss or downplay issues, then that attitude will filter across the organisation. So yeah, just to finish from me, I think within the team we obviously have a lot of experience in providing training on preventing sexual harassment in the workplace, including advising on carrying out risk assessments. So obviously, if you think of today that will be beneficial to your business, let us know. And clearly, by engaging in training, that will go some way to help demonstrate that you're taking all reasonable steps. So, thank you.
Okay, so this is the bit about the Employment Rights Bill, which Lauren and I are going to do together. Lauren's had an unfortunate accident with her arm, which isn't a disability, it's a short-term thing. So it's not affecting a normal day-to-day activity. But nevertheless, as what would otherwise be a reasonable adjustment, I'm going to be in charge of the clicker, which is demonstrate what a great colleague I am, just to get that on camera. So we're going to talk about the Employment Rights Bill, which probably will be the biggest change in employment legislation, it's said, in a generation, and I don't think that that's any exaggeration. I think the changes will be huge, will affect all businesses. They will, according to the ministerial forward on the roadmap for delivering change, it It makes sense for businesses and workers, and this is how we will deliver a new deal for working people, fixing our broken labour market and tackling poor pay, poor working conditions and job security so that people across the country feel the benefits. So whether it makes sense, I suppose, will be for you all to determine over the months and years ahead. But we're not going to talk about every area of the bill because it's a big piece of legislation, but we're going to touch, I think, on some of the most important areas, and over the months to come and in future HR breakfasts, because this is going to take a while to come into effect, and we will probably talk again about some of the issues that arise through the bill. So first of all, I'm going to talk about fire and rehire. So this is one of the areas that the bill is intended to address, or in the roadmap and in the consultations. This is what was described as the scourge of fire and rehire. Now, I don't know whether anybody else can think of lots of cases involving the scourge of fire and rehire, but I can really only think of one and maybe two. I think that really what sits probably behind this is that was a big furore about the P&O ferries matter that many of you might remember from a couple of years ago. And so that was a big issue where 800 seafarers at P&O ferries got dismissed instantly because the business said that they were in real financial difficulties. And it was made worse by the fact that the manner of dismissal included terminations which took place by pre-recorded YouTube videos or something like that. It didn't go down well, and text messages. 800 people out. And then P&O brought in agency workers in order to do that work. Had a huge political fallout, and against the background of, I think, in 2 years previously, there'd been a massive payout to shareholders, and they had also taken huge advantage of the furlough payments. So that was really the scourge of fire and hire, apart from another maybe slightly smaller profile case of Tesco's. Anyway, how does it affect you? It affects you because what this is about is changing the parameters that there are for businesses that want to change their terms and conditions. That's what it's about. And so the way that things, I guess, until now have always been, is that if you want to change the terms and conditions of employment for your employees, then you would consult about that and you would negotiate, and as a last resort, and it would almost always be as a last resort, the point that you would reach is where you would say, well, if we can't reach agreement on that, then what we're going to do is going to terminate your employment, usually in accordance with the terms of the contract, which means we're going to give you your full notice, and then at the end of the notice period, we're going to re-offer you employment, but the re-offered employment is going to be on the new terms. So take it or leave it at that stage. And it was, frankly, a smart move for businesses, because then, even though you risk a possible claim, the consequences of that would be mitigated by the fact that you would be at least able to say to those employees, but you're not actually going to suffer much loss, are you? Maybe sometimes in pay cases, perhaps you might suffer some loss. But the reality is, we're saying you've still got a job, so you can't go off to an employment tribunal and say, I'm losing thousands of pounds because I've been dismissed, because your employer has said as part of this process, we're giving you a job. Now, that's not what happened in P&O ferries, because in P&O ferries, they just said you're all sacked today. That's what it was. But that's not what happens in most of these instances. But the new rules, or the proposals around the new rules, at least in the first instance, was to say, you're not going to be able to do that. You're not going to be able to fire and then rehire. And you're not going to be able to fire and take on agency workers, because if you do, that will be deemed an automatically unfair dismissal. That was the starting point. Everything that we say today will be relatively fluid, because these things are going through the process and there will be more consultations. We'll come to that later. And in the original proposal, the exception was going to be the only circumstances in which you could do that is really if your business was in extreme financial difficulty. Now, P&O Ferries said they were in extreme financial difficulty, but that's the starting point of the Employment Rights Bill proposal. It'll be automatically unfair. There's only one get out, and that's if you can get through the gateway of saying this is to save our business. it is through the various readings and amendments likely that that's going to be extended, so softened, so that it will only be an automatic unfair dismissal if you're trying to make changes to restricted variations. So the things that they're saying we hold most precious, that you can't use fire and rehire for, are going to be pay, working hours, pensions, shift times and length, and rights to time off. So basically, your money, your time off, and your hours, that holy trinity of really important employee rights. And then anything else that you might try and put in a contract so that you could change those things further down the line. So it's softening the approach, but it does mean at the moment that that's the position in relation to fire and rehire. It doesn't mean that if there are terminations for non-restricted reasons, that you could still have potentially ordinary unfair dismissal claims. So that is still preserved. That's the current position on that. So non-restricted variations where there is terminations for other reasons. So, for instance, if you're changing the place of work, then you'll still have to consult on things like that. They'll take into account the reason for the dismissal, what consultation you've had with employees, and then incentives that you might have tried to put forward to employees in order for them to agree to changes.
So I'm going to talk a bit about the changes to bereavement leave for pregnancy loss. So the current position is you only get 2 weeks parental bereavement leave if you lose a child under the age of 18, but that includes if you were to have a stillbirth after 24 weeks of pregnancy. There's currently no right to leave if you suffer a miscarriage pre-24 weeks of pregnancy. Obviously, some employers might still give an employee leave for that, whether that's sick leave, paid leave, compassionate leave, but there's no statutory right to it. So the Women and Equalities Commission produced a report highlighting their concerns about this. As part of that report, they produced some statistics that said 1 in 5 pregnancies end up in a miscarriage before 24 weeks, so it's something that is happening relatively regularly. And they highlighted this concern in the report to the government, who have taken that report into consideration and proposed this amendment to the Employment Rights Bill. So the new position is going to be that employees who suffer a miscarriage or stillbirth before 24 weeks of pregnancy will have a right to 1 week's unpaid statutory leave. So you don't have to pay them. Some businesses might choose to pay them for that leave, but they will have a right at this point to take off 1 week leave if they were to suffer that. What's interesting is that also would include failure of implantation if somebody's had IVF. So if they've had the eggs put back in and then that's failed, it's looking likely that that's going to be covered by this statutory leave as well. And just final point, this is a day one right. So the moment an employee starts working for you, this is going to be a day one right that they have. They don't have to work for the business for a certain period of time. This leave kicks in from day one.
Next, and James kind of touched on this, is around non-disclosure agreements. So, initially the Employment Rights Bill didn't include references to to non-disclosure agreements. And so, what's this all about? This is all about preventing, effectively, employers gagging employees to silence people who've been the victims of sexual harassment and discrimination. Again, as James mentioned, to movement and the greater propensity, I suppose, for people now to complain about sexual harassment in the workplace. This is about stopping principally settlement agreements from protecting the harasser, the wrongdoer. Although, of course, in some instances, the allegations might be made and it might be protecting both parties. But that's what this is all about. So what it's saying is that under the provisions of the Employment Rights Bill, any term in an agreement, in a relevant agreement, that seeks to do that, silence employees, will be null and void. Is this a huge change? In fact, maybe in some instances actually not. There's been some guidance that was issued by our regulatory body, by the SRA, initially in 2018 and then updated about a year ago, which was telling us about our responsibilities in terms of the use of gagging requirements in settlement agreements. And so already we find, and I know Lauren dealt with a case fairly recently where, which was about a sexual harassment case. I think perhaps in the first draft there might have been a gagging provision in there. You only need mention that to your opponent to say, I'm just reminding you about the warning notice that we got from the SRA, and it usually comes out anyway. So there are, in fact, on the ground already provisions in place that prevent that from happening. There's more work, I think, to be done. The current bill isn't clear about what accepted agreements might be. There was some talk about whether it might include settlement agreements. It won't. It won't be that there's going to be an exception for settlement agreements on a blanket level. Where it is potentially still likely to be enforceable, and this would still be the case notwithstanding that SRA notice, is if perhaps the employee or the victim of the harassment is the person that says, actually, I would like the confidentiality clause in there, perhaps to protect them. So this is usually this clause which is saying you cannot talk about the terms of the settlement, the fact of the settlement, or the circumstances leading up to it. The provisions at the moment don't apply expressly to the failure to make reasonable adjustments. I'm not sure why that is. And then there is some discussion about whether or not it would include victimisation claims. I think actually a proper reading of the Employment Rights Bill is that it probably does mean that you can't gag against victimisation claims. Whilst it doesn't say it explicitly, it talks about discrimination and the employer's response to discrimination. And usually victimisation claims are about the employer's response to the discrimination. So there'll be some changes there.
So I want to talk a bit about guaranteed hours and shift cancellations. This is where the hospitality industry in the room ears perk up, because it's one that's probably going to apply more for you. So this is an area that's currently got some proposals in the Employment Rights Bill, but they haven't been formally decided how they're actually going to work in practice. So it's one of the ones that the House of Lords, when it's gone, the bill's gone to them for their reading, have proposed some amendments. I'm just going to talk to you a bit about where we think that is and what those suggested amendments are. So the current proposal under the bill is that there will become a duty on employers to offer guaranteed hours contracts to employees who are on 0 hours or low hours contracts that work regularly over a reference period. So the current proposal is that reference period will be 12 weeks. It hasn't been written anywhere that that's what it's going to be, but it's looking like from the commentary that it will be 12 weeks. So what that means is that if you've got an employee who's working regular shifts, who's either on a 0 hours or a low hours contract, they're working regular shifts over a 12-week period. At the end of that 12 weeks, you would have a duty to have to offer them a guaranteed hours contract for however many hours they've been working in that 12-week period. They don't have to accept that. They can stay on their 0 hours contract if they want to, but then another 12 weeks would go by. You would have to offer it again at the end of that reference period. So it's quite a big administrative burden on employers to manage that, and obviously undermines the point of a 0 hours contract, which is sort of where this is coming from. The government want to try and get rid of 0 hours contracts, or certainly reduce their usage. So the duty will arise, as I said, at the end of every reference period. There are equivalent duties for agency workers as well, so it's in a slightly different section of the bill, but it would apply to agency workers as well. And so when this went to the House of Lords, it was criticised quite heavily by them because of the administrative burden on employers to keep reviewing it at the end of every reference period. So what they've proposed is that instead they think it should be that the employees have a right to request a guaranteed hours contract. And so then if they requested it, an employer would have a duty to have to provide that to them. And if they don't request one, then they would just carry on their 0 hours or low hours contract as they've been employed on. That would make the process simpler, and it would still meet the government purpose of potentially reducing 0 hours contracts, but it hasn't been accepted yet. It's been proposed by the House of Lords. The bill's going to go back to the House of Commons. They may well say that they don't agree with that amendment, and it stays as it is. So it's one to keep an eye on. In either situation, this guaranteed hours section is going in. We just don't know how in practice that's going to work yet. The other important bit is the shift cancellation. So they are also looking to introduce some sort of compensation for employees if on these 0 hours or low hours contracts, they have a shift cancelled at short notice. So the proposal at the moment is that an employer will have to pay a specified amount by a specified date. Neither of those things have been specified yet. If it cancels, curtails, or moves a shift at short notice, where one of the following situations applies. So where the employer has informed the worker that they're required to work the shift, where the employer has requested that the worker work the shift and the worker has accepted it, or where the worker has suggested that they work a shift and the employer's accepted it. So basically where there's become an agreement between the two that they're working that shift. It only applies to qualifying shifts, which is essentially shifts under 0 hours contracts, either employees or workers. They are going to define some shifts in the regulations that count as a qualifying shift. They still haven't done that either. It's likely to be that it's similar to low hours workers rather than just the 0 hours. And again, if there's an extra shift offered to an employee who works regular shifts, so if they have contractual shifts, so they work those set shifts every week, but then they're offered an extra shift, they accept that, and then it's withdrawn, this would kick in as well. So in the current proposals, short notice hasn't been defined. We don't know what that is yet. The House of Lords, in their reading of it, have proposed that that would be defined as within 48 hours of the shift starting. Again, hasn't been confirmed yet. We'll have to see where it goes. But in any event, some sort of shift cancellation provisions are looking likely to be in the legislation.
Okay, unfair dismissal and day one rights are probably the biggest area, I think, of concern for employers, not unreasonably, because unfair dismissal is the biggest area of claim brought in the employment tribunals and probably always has been. The qualifying period at the moment, of course, to be able to bring a claim for unfair or constructive dismissal is 2 years. Unless you've got those 2 years service, you can't bring one of the most popular, if we put it that way, sorts of claim. It's 2 years now. When the legislation was first introduced, it was 2 years, but it has moved around a bit actually over time. It went from 2 years, and then some years after that, it dropped down to 6 months. Then when it went up to 1 year, when I qualified, it was 1 year, and then it went up to 2 years. And so now, of course, the headline is that it's day one. It's a removal of the qualifying period, and that's the plan. The plan is that in the primary legislation, that's what the Employment Rights Bill is here, it's the primary legislation, and what will get tacked onto all of this is lots of secondary legislation and guidance and codes. But in the primary, they could have just changed, left the primary legislation and just reduced through secondary legislation the period down to a lesser qualifying period. And that the House of Lords have proposed that it should just be moved down to 6 months. That's not what they're doing. The proposal is to make it more permanent and more difficult to change in the future. But it would give employees the right not to be unfairly dismissed right from the outset. So big changes. The softening, if you like, of this is that there would be a modified procedure that would be available to employers during what everyone is calling a probationary period. And then there has been discussion about what that might look like. And so it's kind of oscillated really between something like a probationary period of 6 months and 9 months. And I think where things sit at the moment is that it would be a 9-month probationary period, and you could use the modified procedure so long as the termination took place within a further 3 months. So all in all, that might give you a year potentially in order to use a modified procedure. We don't know what the modified procedure would look like, but we've probably got a fair idea that it would involve a meeting. Some of you might remember we had modified procedures, or that was the last time I remember us talking about modified procedures, back in between 2004 and 2009 when we had different procedures around that. That didn't really work very well, so we got rid of that. And so this is intended to give job security. It's one of the stated aims of the manifesto, and also I think the optimists say, and I think to be fair, even the ministerial forward says it, is that what it will do is it will reduce the much more complicated cases that the tribunal now has to deal with because of the people that don't have 2 years service. So they're saying this is the picture. The picture is this, that you're an employee and you've been dismissed, and let's say you've only got a year's service, or certainly you've got less than 2 years service, and then you come and see somebody like me, and you say, I've been dismissed, and I say, how long you work there? And they say, I've only been there for a year, and then I put the phone down fairly swiftly because I think they're not talking to you any longer, you've got no claim. Not really what happens. I say, a year, what do you think was the reasoning behind it? And then they would give me their reasoning, and then in order that I can satisfy our insurers, I say, right, okay, so you've got no rights to claim unfair dismissal, because that means you've got to have a qualifying period. There are some claims you can bring without a qualifying period, and they include all of the areas of discrimination, and they include whistleblowing, because I've got to let my client know their rights. And then sometimes, only very occasionally, the client will then think, well, maybe I do have a protected characteristic, and perhaps maybe I am disabled, or maybe it was because of my age, or maybe I have complained about whistleblowing, I've raised a health and safety issue, and that probably is the real reason. And then you bring what you might think, cynically, a much worse claim that takes much longer in the tribunals to fight, and the tribunals say, we need to get rid of these, because if we give everyone unfair dismissal employment rights right from the start, then at least we're only arguing about unfair dismissal, and that's going to be a shorter hearing, might be a 1-2 day hearing, rather than having to have preliminary hearings about whether the person is disabled or not, and so on. So this is why I don't think this is quite going to work, because if we're going to have even a modified procedure in the probationary period, and that's going to involve saying to an employee, which a lot of you might consider this to be best practice anyway, that you might say, well, there's an issue with your performance, or you just don't turn up to work on time, or don't turn up at all. So we're going to have a meeting about that. Now the employee is ticked off about that, they come and see me at this stage, and I tell them all of the same things. Does that make them more or less likely to add in a claim which not only do they not need any qualifying period for, but the other thing about those discrimination claims and whistleblowing is that they're worth more money, because you get injury to feelings for them, you get non-pecuniary loss for them. So now, when I'm talking to the employer, and the employer says to me, I've got this employee, I'm just double checking with you, with performance is bad, got less than 2 years service, you might not even check with me, but if you did, you'd be, and then we'd be talking about it, should we go through a procedure? I'd be saying, no, don't go through a procedure. As soon as you tick them off, there's going to be a procedure. Guess what? That's increasing your chances that they're going to be raising disability issues, age discrimination issues, whistleblowing issues. So SAC can be done. If you don't know about any of those things now, you're in a safer position. I'm not sure that having even a modified procedure from day one is going to reduce the number of claims. I think there's a danger that we'll just have more claims, because unfair dismissal is really popular already. People love it. It's the most amount of claims that we already have. Add in the possibility that you can increase your winnings from that by adding in some other protected characteristic. I don't think that's going to make it less popular. Anyway, that's just a personal view. There we go. So yeah, there are proposals about that, about different qualifying procedures, periods, and making the process simpler. Well, I think it won't prevent employers also having their separate other contractual probationary periods. So you could still say, for instance, in whatever the government decides in relation to the sort of statutory procedure where there might be a modified procedure, you might say, well, we want to see what you're like first, and we're not going to let you have these benefits, these certain benefits, until you've served a year, let's say. So that you might be thinking, well, let's reduce my exposure to the possibility of the losses further down the line. So that's what we'll come on to some other things to think about when we talk through the timings, but that's one point just to pick up on that. Right, now we're on to the timings.
Yeah, so the government have produced a document that they've called the Employment Rights Roadmap of when they think these things are going to come into force. For what is quite a large bill, it's actually quite a short document and provides very little detail. But we're going to go through sort of some of the timings and what we can expect coming up in the next sort of 2 years, it's looking like. So, first thing that's starting this autumn is the government are going to, or are expected to, launch a large number of consultations. So government consultations are where businesses, individuals can feed into and answer what is essentially a bit of a survey produced by the government for your thoughts and opinions on how certain things are going to work. So they're planning to use this to feed into the regulations. Now that's either going to assist with getting the final draft of the bill agreed, or it's going to probably more likely feed into drafting guidance and ACAS codes of practice for some of these new pieces of legislation coming in. So the first sort of consultations we're expecting to launch this autumn are about trade union measures. So that's going to include the proposals to use electronic balloting, workplace balloting, simplifying the trade union recognition process, which is quite a complicated process at the moment with agreeing between the business and the trade union whether they're going to be recognised, and then the powers that the trade union have to then enforce recognition. The duty to inform workers of their right to join a trade union and trade unions' rights of access into a business. Now, the new rights and protections for trade union representatives will be covered by an ACAS code of practice, so that's what they're going to be consulting on in terms of how businesses feed into that. There's also going to be a consultation on dismissal and re-engagement, so fire and rehire. I'm not going to talk to you about that, Kevin's already been through it with you. The regulation of umbrella companies, so that's where there's a company that essentially employs somebody who's self-employed and then who's in reality more likely self-employed, and then recruits them out to other companies. So it means that they get the benefits of being an employee, but they actually have the freedom to work for multiple businesses. Bereavement leave. So some of what I've already talked about in terms of the parental bereavement leave, but there's going to be a consultation on whether general bereavement leave should be extended and what that might look like. Increased rights for pregnant workers. That's mostly, we think, going to be about increasing pregnant people's rights to not be dismissed. So it's looking like there might be only specific circumstances in which you will be able to dismiss an employee who's pregnant or potentially has been pregnant within the last 6 months. Again, there's not really a lot of detail around that, and I think that's essentially why they're doing a consultation on what that might look like. And then ending the use of 0 hours contracts. So some of what is already been discussed in terms of guaranteed hours and shift cancellations, but generally consulting on whether there's just going to be a blanket ban of 0 hours contracts. If you think that you would like to feed into those consultations, you just have to do a little bit of a Google and you'll get taken to the government website where you can find all of the government consultations. You can see the ones that are currently open. I had a little look yesterday. There's about 3 pages worth of consultations. None of them are currently related to employment or the Employment Rights Bill. But we are thinking that this autumn they should all be being launched. So it might be worth feeding into it if you have strong opinions about how any of these things work.
Perhaps I should have mentioned that in autumn, but I think it was summer autumn is what it said in the government roadmap, is that the consultation on giving employees those protections, those day one protections, is the time frame. They're probably already a little bit late for summer, autumn, but that, on the basis that I think that's one of the biggest impacts, that's one where the consultation is starting, or should be starting the earliest, and the implementation happening the latest. It's going to happen because of the impact. So then rolling on through time, so we're still in consultations. There will be further government consultation on more trade union measures. There's quite a lot of trade union stuff. We're not touching on that today, but there's a lot of trade union stuff that's going on in the bill, and they will be, I think some of the trade union changes will be the first to take effect. The tightening of the tipping laws, that's already happened actually in the last year. Jake Madison team wrote a great article about that. That's on our website. I think that's been about a year, so there's going to be further changes in relation to that. And also, we'll probably run something again. Claire Hollins and the team did a roundtable with some of our leisure clients that if you're in the sector, you'll be invited to, and that was all around some of the particular issues there. We'll probably rerun something on that. Collective redundancies, there will be consultation on, and then flexible working about day one rights or flexible working consultation in that period.
So then April 2026 is when it's looking like things are going to start coming into force, or certainly are predicted to. So the first one is the collective redundancy protective reward is going to double. So at the moment, if a business is required to carry out collective consultation because they are having a large number of redundancies in a short period of time, that award, if they fail to do it, is currently 90 days gross pay per employee. That's doubling to 180 days gross pay per employee, so quite a significant award. What I will say is that's the maximum amount of the award payable. It's not guaranteed that that's what an employee would get, but it's certainly designed to encourage employers to actually carry out the collective consultation process. It is a bit of a complicated process, and so some businesses fail to do it just because they don't understand how to do it properly. So take advice if that's a situation your business is going through. It's certainly something we can advise on. Then it's going to kick in that paternity leave is going to be a day one right. So at the moment, you currently have to have got 26 weeks service before you qualify for paternity leave from a business. And that is changing. So again, it will be a day one right. Similarly, the unpaid parental leave is going to also become a day one right. At the moment, you currently have to have worked for a business for a year before you are entitled to that type of leave. And again, that's now going to become a day one right. And then what I think is going to be quite a big change and impact employers, certainly in terms of payroll, is the removal of the lower earnings limit and waiting period for statutory sick pay. So at the moment, statutory sick pay doesn't kick in until the 4th day of absence. So the first 3 days, you don't get any statutory sick pay, it's unpaid. That is going to be changed and is going to be reduced again to day one. So statutory sick pay will now be being paid from the first day of absence. And then also the lower earnings limits is going to be removed altogether. So at the moment, SSP is not payable if an employee earns the lower earnings limit or less. They wouldn't qualify for statutory sick pay. That's being removed altogether. Now, the problem with removing it altogether is that some employees who don't earn the lower earnings limits would actually get paid more money on this. They are dealing with that, and the way that they're dealing with that is you will either be paid, if you're on that lower earnings limit, you'll either be paid statutory sick pay or 80% of your average weekly earnings, whichever is the lower. So they are dealing with the fact that that would cause companies issues. So yeah, some big changes for FSP predicted to come in April.
And if you're joining the dots between fire and rehire and whatever your sick pay provisions are, then I would say that probably should be fairly high on your shopping list of things to have a look at. If there's ever a time to review whether or not your sick pay provisions are fit for the future, and you might be thinking about changing them further down the line, you'll do that now rather than try and do it further down the line. So then we fast forward to about a year from now, where the ban on fire and rehire, which should come into force. Same with the rules on the allocation of tips that I mentioned, the introduction of the all reasonable steps to prevent sexual harassment. And so that's really just tightening up that duty which already exists right now. I think precious few employers are looking at that, are going through the training. You might tell me different, but I think lots of employers are missing a trick on that. That's another one to have on your shopping list. On the basis that you're not going to be able to use settlement agreements to cure all ills if you've got really damaging sexual harassment cases in your business, clearly by far the better approach is to make sure you don't have them in your business in the first place. So you should be that should be a priority. It's really, really expensive to get wrong, and it's going to get harder to fix. Then the same with about claims in relation to harassment of employees by third parties. I think that's probably a big issue for lots of industries, but I think in leisure in particular, the possibility of customers harassing your staff when they're intoxicated, the real risk there. Bringing in the duty to inform employees of their right to join trade unions. And then we haven't mentioned the extension of the time limits to bring an employment tribunal claim, which would be moving from 3 months to 6 months. So this is already moving out. We're talking about this. I mean, the tribunal system is under huge strain at the moment. There's been I think the stats are, there was 23% increase in the last in the number of claims for the last period, or maybe that's from this year compared to last. I can't remember. Anyway, the broad trajectory is that there are many more employment tribunal claims. So if people get longer to initiate their claims, moving that limitation period out from 3 months to 6 months, that's going to have an impact upon claims. What it's also going to have an impact upon is how prepared you might be as employers to deal with those claims. So at the moment, if somebody you sack them today, they've got 3 months to start ACAS early conciliation, which keeps their claim alive. So you might not know that you've got a claim yet, but they might have contacted ACAS to do early conciliation. Early conciliation lasts 6 weeks. In lots of the offices, we know that ACAS can't deal with the number of cases that they've got. So you might not hear from anyone in ACAS during that 6 month period. You might hear something in writing, but you might not get any conciliation. Now we're 4.5 months down the line. They issue their claim in the tribunal. The tribunal takes a month, maybe sometimes 2, can be longer to process it, to send you out the claim. So even as it stands, what we are now, we're 6.5 months in before you get the claim form. Add another 3 months on top of that. That might be the time when you're now saying, okay, who are all the witnesses for this? And can anyone remember who this person was and what happened? So I think that makes a change about how you document things, about maybe front-loading claims. Normally, witness statements are the very last thing that you do when you're preparing for a tribunal. That makes good sense. They're costly to put together. So if there's a chance you might settle it before you put together the bundle and the witness statements, all the things that cost you loads of money. But maybe, I would be saying to businesses, maybe that's an area you would be thinking about, maybe training managers, at least be getting draft witness statements at early stages, so you're not relying on people's memories for things that might have happened many, many months before. So I think that's an area to have a look on and get prepared for.
And then finally, they're looking like the last few things are going to come in 2027. We don't know when in 2027. They've just given us the whole blanket 12 months of when these things might come in. So the first thing on the roadmap is this ban on 0 hours contracts. But again, we don't really know what that's looking like. We just know that they've talked about it. They're going to be consulting on it. The only detail we've got at the moment is these guaranteed hours changes, which also are going to be coming into force in 2027, so the guaranteed hours contracts that you will have a duty to offer. Day one right for unfair dismissal, Kevin's talked in depth about that. I think we're all pretty pleased that that's been pushed into 2027, so we've got a bit more time to think about how that's going to work. The new redundancy collective consultation threshold, so they're going to add an additional threshold of employees being made redundant, at which point collective consultation will have to kick in. Again, they've not given any details as to what that threshold of employees looks like or how they're defining that, but they've said in this roadmap that's something that's going to be coming in. The reasonableness requirement to reject flexible working requests. Again, I think this is going to be a pretty big one. So at the moment, a business can reject a flexible working request if you meet one of the 8 business reasons for rejecting a request. And as a business, all you have to show is that you have decided that one of those reasons is in place. What's now going to be being brought in is that you've got to show that that decision was reasonable. And so you're going to have to be able to provide evidence to say why that decision is reasonable. You can't just rely on one of the 8 business reasons. So that will make rejecting flexible working requests more difficult, and will make sure that you need to have certain paperwork in place to show why you've made that decision, keeping a good record of conversations you've had with the employee to explain why it's reasonable, all about creating a paper trail, essentially, as well as actually having the reasonableness of the decision. So a tribunal will now look at what they think is reasonable. They won't just take what the business is saying in terms of those 8 business reasons. And then finally, in day 1 right to bereavement leave, again, we're not sure what that's going to look like in terms of what the bereavement leave changes are going to be, but it's going to become a day 1 right. And then increased rights for pregnant workers. So I've already kind of talked about that. We think it's going to look like this in process where it'll be slightly more difficult to make employees who are pregnant or to terminate their employment. But again, we don't know what that looks like yet. That's part of what the consultation will be about. That's it.
So it's phased, but it needs to be because there's a lot. And we haven't even talked about everything that is in the Employment Rights Bill. So, brief advert. Stay with me. Maybe also a public service announcement to our clients who have a retainer with us. So, many of you, if not all, possibly not all, will have been contacted about kind of an augmentation in that service where there's a portal that's available to you where we'll share the documents that we have with you, your agreed policies and procedures and contracts, and we're going to be putting more information on that portal in the weeks and months ahead. That we've mentioned that we do training for, again, clients who are on retainers. There's discounted training for you. So there's, I think, stuff to be getting on with. In terms of the, I guess, the broad picture on that. Obviously, the fact that you're here means, I suppose, you're looking at all of these things. As I say, we'll be looking at more of these changes as time goes on. I think if there's the sort of action points that I would just put on your radar is around reviewing your recruitment processes. On the basis that that's going to be one of the big areas, then I would be saying recruitment decisions are, and I know speaking to people beforehand, I know recruitment is pretty tough out there at the best of times. So getting people is your first priority. Never mind getting great people, but you might find these people, are potentially a bit more of a liability when you have got them. So the more that you can do up front to make sure that you're getting the right people in your business, the better. So more competency testing, more screening. I don't know how many people really do follow up on references in greater detail. Some of those processes I would be reviewing if I were you to look at payroll, which as Lauren has mentioned in relation to, and your policies in relation to sick pay and your sickness absence terms. I mentioned that. I mentioned the point about training managers to front load gathering evidence. I think where you can do that helps us and it reduces your costs. If you can at least be getting together pretty decent first drafts of witness statements early on when you've got disputed cases. And I think if it hasn't already been obvious to businesses, this point around prevention of sexual harassment, the message is not really getting through, I think, in many instances. I mean, I don't know, it's been in the press for a long time, but we still see plenty of cases involving harassment, some pretty terrible ones going on in the workplace. So I think the people who aren't listening, they're just not getting the message on that. So I think it's the responsibility of businesses to be making sure that training is there. It's pretty difficult as it stands to be able to put together all reasonable steps, defences. There's going to be more guidance on that. They say that as part of this consultation. So we will know more as we go on. But I think that's a big area. It's costly. It's bad for business. It's bad for your reputations. So I think those are the areas that I would concentrate on, looking at it from our perspective.